lawyers to go elsewhere to practice and they'll be seen as people who are not up to the scratch. We want the top-notch. We want to produce top-notch lawyers. So quality control must be throughout the system. But we believe that you can establish a system and you don't need 6 months to do that. But you just need a pen to give directives that XYZ institutions of learning have been accredited to do these courses, that they need to have this faculty, that the facilities must be that, and then allow the Board of Legal Education. That's why I believe that LI 2253, even though a stopgap measure was not necessary, allow, and the regulation LI 1296 already talks about the Board of Legal Education setting the examinations for qualifying to the bar to be admitted onto the role of lawyers. I thought that the best way and the neater way to do it was to allow to accredit tertiary institutions, let them run courses, give them the syllabus, in effect, set a standard, and then at the end of it all, get the Board of Legal Education to set questions for all the students, standard questions for all the students to write. There will be competition there. Competition inures to the benefit of the consumer. If institution A is not producing well, and the results will show, students will gravitate towards the institution that is performing well. The institution that is not performing well will have to sit up and up its game if it wants to stay in the game. Now then, after being called to the bar, you set a procedure for internship. You have to register the firms, also see their capacity. Let them go through internship for a period of 6 months, and then you can then call them to bar. Upon assessment, call them to the bar. Then they now begin their pupillage of 6 months. I thought that doesn't require any amendment to the LI. But what has happened is further delaying, I hope not for too long, the process of initiating reform to ensure that people who want to be trained as lawyers get the opportunity. And there are many people, and Madam, everybody knows that the Attorney General's department needs a lot of lawyers. Everybody knows that the district assemblies need lawyers. In fact, it is better to have lawyers walking the streets and not working than being illiterate persons walking the streets. In fact, it is better to know our rights as lawyers, struggling to get employment, than restricting and constricting our access to law school. And that is my position, and that is the position of a greater number of MPs, both on the majority and the minority side, except that things happen in Parliament.
Politics happen.
Things happen. Things happen in Parliament, and we need to understand that the whip system that we practice clearly sometimes will make people vote in a way that will not cause embarrassment.
Okay. Mr. Cindy, thank you very much for that. And great suggestions there. Great suggestions. And so we'll come back to interrogate how you voted today, because it's important with all that you said and why your vote didn't matter at the end of the day. The reason why I'm reserving the Attorney General for last is obvious, because you've raised a lot of issues that she will have to respond to. And I'm guessing that Maxwell, Kofi Bentil, Prof will all raise issues that eventually the Attorney General will have to respond to. And so I'm going to ask Maxwell to also, I guess, Maxwell Pokwajuman, to also, I guess, lay out his own thoughts on this matter, and then hear from Mr. Bentil and Prof. H. Kwesi Prempeh. Just join us. Prof, thank you very much for joining us. We are grateful, sir. And then we'll hear from the AG finally. Then I'll invite my audience to engage with questions.
Well, thank you very much. I think I also have to express my gratitude for the invitation, and also sitting with the Attorney General, who always call me Teacher Maxwell. Well, it's a great opportunity. I have been yearning for this opportunity. In my view, first and foremost, I think I sit here in two capacities. First, expecting students who are clamoring to enter the law school, who maybe those who have not entered may be considered not my students, but at least as a teacher has a compassion, because it's a compassionate job, and therefore, whether they are in school or just seeking to enter, I think I considered myself as a shepherd, and as a shepherd, we always have to protect those people. The law school problem, I think, we should not be using emotions to resolve the issue. It is a very complex issue, and therefore, moving forward, I suggest that we should conduct a multi-stakeholder summit of almost all those who are, so that it doesn't become a media warfare or political turf game, but rather something that will also endure for the next 60 years, because those who set up this law school managed to set up a system that has lasted for 60 years. It's crumbling over our eyes. I have been, for the 60 years, at least I have been involved for 23 years. And therefore, I can say that sitting here, it is not a very good thing. I mean, the system is crumbling. And it seems we are paying more attention to admissions rather than the substance, what is going on. It is amazing. To me, there's nothing to write home about, because we are producing now what I call examination machines rather than competent and proficient lawyers for the future. And if we don't solve it and we produce and admit, it's going to be the same. And so therefore, admission, yes, but in my view now, we should have a multiple approach to resolve this problem. Of course, the law school, in 2009, I listened to what Samson was saying, as if in 2009, I was the secretary to a committee to bring out proposals when we realized that so many faculties were springing up. And as a secretary to the committee, we produced two alternatives. The first one was what we call the multi-campus approach, which was to set up other campuses from Makola, which is the main campus. It was based upon it that we adopted this quota system to deal with the numbers which were coming. So I remember we giving Legon 80, KUST was the only one then, giving them 60, and then Zenith for all these London School, LLBs, we give them 50. So in total, we were looking at 150, which was working very well. But sometimes we forget about the faculties. As soon as we brought this quota, some of these faculty deans who were also members of the council went back, and all of a sudden, for example, University of Ghana has maintained the 100 plus, but KUST came in with 60, then later they moved to 261. They admitted 261. And then, of course, GIMPA came in. Then the worst of our nightmare was Mount Crest, which admitted over 400. So if you add KUST and Mount Crest alone, we're moving to over 600. That clearly made the quota system unworkable. So then we have to move on. The next alternative that we proposed was that if looking at the numbers and the faculties, there was no way we can sustain the Ghana School of Law as it is. So we proposed that same thing that, in fact, we proposed and started doing the legislation, that is, we should convert the Ghana School of Law into the Council for Professional Legal Education. And then we have these departments. We propose the Department for Accreditation, Department for Monitoring and Evaluation, Curriculum Research, Continuing Professional Legal Education. Then we came out to the Independent Examination Board. So the Independent Examination Board was for the second alternative. But nobody knows. In this country, the way we do things, they sat down, picked the multi-campus system, but nobody knew what happened. Then they took the IEB, which was the Independent Examination Board, which was the second alternative, and added it to the first alternative. Then we said, it is impossible to have a running faculty, and then there's no synergy of teaching and then examination. If you do that, and then they gave an argument of WAEC, and I said, some of us argued and said, no, even WAEC, I have been an examiner for 15 years as government examiner, because I was teaching government. All examiners must be subject teachers, just that we examiners set questions for our chief examiners, and the chief examiners have moderators. But then, the way we have now, that's why I said, apart from the admission, I see a bigger picture when I look at the mass failure. Let me be honest and say that I disagree with those who say students are lazy and that the students are dumb. Because I have been in the system, therefore I have been a referee for so many of these lawyers. And I can say they are very serious, very committed, but the system is against them. Because you come to school 6 a.m. and leave there 7 p.m. What time are you going to read? And I am not going to reduce the number of my cases because you have more hours to spend. I will give the cases that I have to give because that is how I do my things. And so when you look at all these factors, I think that we have to come out with, so that not only the admission process, because the admission process was necessary. It was a necessary evil because the law school, the library cannot take even 100. Now 568 students, that is what we have. I am a person who do participatory approach in teaching, but now I can't even see some of the faces of my students because they are far away in the class, and sometimes the spaces are also not available. So going forward, I am of the view that we have a bill which was prepared 2005. I think we have, it has outlived its usefulness. Now what we need to do is to come out with this Council for Professional Legal Education. We have to dissolve the law school. Now that we have set up an IEB, then we have to go to the second model, which means then accredit, have your curriculum development session, and then have an independent examination so that they come and write the bar exam. If bar exam, at the end of it, only 2 people pass, I think you have given them the opportunity. In fact, we also propose, you propose something called Qualifying Certificate of Legal Executives, where we're going to, because we have realized that out of 7,518 of our products, only 3,000 are active with the bar, which means most of them have been dissolved into other areas. It seems to suggest they are not interested in courtroom practice. But it seems our training is geared only towards courtroom practice. So every time you say the courtroom is full, but other places are empty. So we suggested that, in fact, I brought this one. In fact, this was developed just to ensure that why can't we train them, say, banking executives, insurance brokerage, so that they can find jobs. These are people who can find jobs who will not be in court. This was proposed, was not accepted, I think that maybe time has come to look at some of these things and then move from the one-dimensional approach to legal education that we have, and if possible, accredit these institutions and then dissolve the Ghana School of Law, because at it is, you can't have a running faculty teaching and then independent examination board setting questions without reference to those who are teaching. Definitely there will be a disaster, and I think that is what we saw recently, and that is my humble view, my experience in the system. And I think the Attorney General will be gracious to lead this multi-stakeholder as the leader of the bar, because it is becoming so sad for some of us that the legal profession is in the news all the time. And I think that the nobility of this profession must always be maintained. Thank you.
This is pretty revealing. Thank you, Max Opoku Prempeh. Thank you very much. And I'm sure the students... Max Opoku, I'm combining HPC Prempeh and... because I was coming next to Prof. Yes, I'm really grateful that you shared those thoughts with us. And I had resigned myself not to pursue legal education because of this, but after hearing you, maybe I'm beginning to change. I'm beginning to change my mind, and I see the Attorney General nodding. I'm waiting to hear from her. What she says, I guess, will make up my mind for me. Prof, it's your turn to share your thoughts with us on this matter. And Professor H.Kwesi Prempeh, I'm grateful that you joined us. Please share your thoughts with us, sir.
Good evening. Sorry, I was late. I had a meeting till about 5:15, so I had to leave the office late. So I would like to approach this from a number of different angles. First, I think the first point I would like to make is that the matter of the production and training of lawyers, as of any profession actually, is a matter of public significance and interest. I say this to underscore the point that we should not see this as a conversation that has to be limited or restricted to lawyers or to the profession. The country is deeply interested and must be deeply interested in the question of the production and the training of lawyers, because lawyers are not trained to serve themselves. They are trained to serve a public. They are trained to serve a national economy. They are trained to serve a society. They are trained to serve a state. So this is not something that we must leave to just the profession, whether it's the bar or the General Legal Counsel. And I think, unfortunately, much of the conversation has been left to be dictated by the General Legal Counsel. And I think that is unfortunate. I mean, we must really all be involved in discussing this matter, which leads me to the next issue of the process by which this conversation has evolved. And as with the first, I think because the GLC sees itself as probably the main actor in this, it has acted without, I think, recourse to the many other constituents and stakeholders who must be heard in this matter. The manner in which the decisions have been made, whether it's with respect to admission quotas or whatever, have usually excluded many multiple stakeholders who I think must have a voice in this. Maybe when the GLC was initially constituted in the 60s or conceived, that was not the process by which administrative bodies made decisions. But we live now in a different era, and I think the GLC must conform its processes and decision-making processes to the norms of democratic oversight and public participation. I think the law students, for example, who are most directly affected by this, ought to have been consulted. There must have been a really consultative process. I'm happy to hear my friend Maxwell suggest exactly that this conversation must proceed on the basis of a multiple or multi-stakeholder consultation. There are many, many different constituents here, including the consumers of legal service. They too must be heard in this matter. And I'm not just talking about the business sector. I'm talking about just average Ghanaians. We are consumers of legal service, and how the production and training of lawyers is organized will affect us in our ability to access the justice system. So that's my second point. The third point has to do with what exactly is the problem. So what is it that we're trying to solve? Unfortunately, when we get to the problem statement, it suffers from clarity. It suffers from a lack of clarity, actually. I have heard many different rationales adduced for why the Ghana Law School or the General Legal Council has chosen to proceed this way. I've heard space, which is the most pathetic of the reasons I have heard. Because when space is mentioned, it's actually physical space. It's actually quite disappointing. That physical space must be the reason for all this brouhaha about the structure of legal education. I mean, that is a very artificial constraint. We can liberate ourselves from the physical space constraint very easily. I do not think that is actually a serious constraint that must detain us for too long, because it doesn't have to exist. The constraint exists partly because we have chosen to hold on to a 1960s model of providing professional legal training that is no longer sustainable. And I think the solution may not lie in opening up multiple campuses of the same Ghana Law School. There are many other options, including essentially liberalizing the very sector, the very idea of providing professional legal training. There's no reason why Ghana Law School must hold on to a Jeffrey Bing monopoly from the 1960s that was crafted to solve a specific problem in that period. So there's really no, for me, the answer to this physical constraint problem really just opens up a number of possibilities. I don't know why the road must lead to this solution of imposing a quota on the admission of law students. I have also heard this issue of oversupply of lawyers. Normally, this is not coming from the GLC itself. It's coming from the lawyers. Of course, some of them must say this because they are afraid of the judges who sit on the General Legal Council. I'm not, see, because I don't practice before any one of them. You know, so Kofi Bentil says I should say the bad things. But, you know, but this oversupply of lawyers problem is, again, it's a false problem. It doesn't really exist. I mean, only recently, my good friend, the Attorney General, was reported in the papers to have said that her department, and I visit the department often enough for me to know that what she's saying is true, that her department alone needs thousands of lawyers to actually deliver the kind of service that they are charged with to deliver for the public. And, you know, that we have the legal aid scheme, grossly under-resourced on a perennial basis. We all know stories of prisoners on remand who can't find lawyers and for that reason must stay in the jails even before their guilt is determined for years. So there's clearly a problem of access to justice that really refutes this claim about oversupply of lawyers. Maybe we're just looking geographically at just a small segment of the market in Accra and just concerning ourselves with commercial lawyers, you know. But even there, I'm not particularly sure that the numbers bear out the claim that we are now in a situation where there are too many lawyers. I, of course, know a lot of people going to law school. I wonder why. I keep asking them why. You know, the journalists, everybody wants to be a lawyer. I don't understand why everybody wants to go to law school, but that's their own problem, right? That is something that they are entitled, decision they are entitled to make. It's a career that's attractive. It's a profession that's noble, and many people are attracted by it for different reasons. Somebody just wants to wear the wig for a day and not practice law ever. You know, I had a classmate in law school who came to law school from a symphony and returned to the symphony, never practiced law for a day. But every time we have class reunion, she's one of the most active organizers. She comes to all class reunions. She never practiced law for a day. That people must be allowed to make that decision for themselves. It's not for somebody to say that there are too many lawyers and therefore I'm not going to allow you to become a lawyer. But again, the facts do not bear that out. Even if it were true, the facts do not bear that out that there are too many lawyers. Then I've heard this argument about quality control. And the quality control argument, again, I think is a red herring, because the quality control argument is about the production of LLBs. And the argument is that the quality of LLB graduates being churned out by these new law faculties, by these many law faculties that are coming on board, is such that we need to just sieve through them and get better quality to be allowed to go to the next leg of legal training. But of course, if it's a quality control problem, for me, that problem exists at a different level than where the solution is being proffered. So the problem is, let's call it an upstream problem, or a production level problem, as I've called it. Why do you solve an upstream problem or production level problem with a retail solution? If the problem is at the production level, if that's where they're producing LLBs, if that's your real concern, why not tackle the quality control problem at the LLB entry level? If that's your concern. And if the schools are not of the quality you'd like, why not regulate them? Why not make sure they have the library resources, the faculty capacity? All of these things are done in other places, in our peer countries, in Kenya, and other places. The regulatory body checks to see these things, and law schools are delisted from the provision of legal education where they fall short of these standards. So the quality control is a real problem. Of course, every profession must have quality control. But the quality problem, as stated in this case, is an upstream problem that calls for an upstream solution, not for a downstream solution. So you don't allow these schools to become just LLB profiteers, producing graduates to become law faculty entrepreneurs, and then once they have produced the graduates, you then say, well, now it's our turn to refuse you entry and giving you an opportunity to qualify as a lawyer. So I don't also see that as a real credible argument. So what's the way forward? I think process-wise, definitely I associate myself with the suggestion by Maxwell that we open up the conversation, right? As I've said, this is not a lawyer's issue. This is a national issue. The same way it would be if it was about the production of doctors or nurses or engineers or any other professional group. So we should open up the conversation, not make it an intra-lawyer discourse, not just about the bar and the bench. And also, one of the reasons why it's difficult to make headway is that, look, there are friends who privately have told me, they're lawyers, say, look, I support this move to defeat this airline, whatever, but you see, the General Legal Counsel, I'm afraid, you see. The law students even will tell you that they're actually afraid because some of their faculty members are, publicly, it appears almost every lawyer likes what they're doing. Privately, many don't. Many fear victimization, many fear reprisals of one kind or the other, which is quite unfortunate, right? Law should be that profession that allows people to vent, that allows people to express their opinion. Lawyers are very opinionated people. So for you to shut down the conversation just because some people fear reprisal because of the nature of the hierarchy in the profession, especially from the bench side, I think it's unfortunate. But I think one of the ways to get around that problem is to open up the conversation to non-lawyers too, who matter in this conversation, the business community, those who are in the other parts of the justice system. We have to bring all of them into the conversation. And then once we've done that by way of process, opening up the conversation, I think we need to put a lot more options on the table, right? We need to put a lot more options. It cannot be a binary solution, right? Lawyers, unfortunately, are binary people. They operate on the basis of prosecutor, defendant, prosecutor, accused, plaintiff, defendant. So they get to most problems, they see most problems in the same binary way. One person must lose, one must win. It doesn't have to be so. And I think, unfortunately, this particular matter is an illustration of that dilemma. Lawyers frame issues in binary fashion. And so one person will have to go home with nothing. You hardly hear a lawyer say it's a draw, you see, or a judge say in the courtroom that it's a draw. But I think we must have on the table multiple solutions. There are just not one or two ways to look at this. There are multiple ways to look at this, and arguably an infinite number of solutions that one can put on the table. So we must put everything on the table, including the solution that I'm familiar with, which is that why must after I get my LLB, why must there be a Ghana law school that has the monopoly in training me to go and sit the bar exam? Why can't you liberalize that portion of legal education, allow any number of service providers to come into the market and use the bar exam? Like Maxwell said, use the bar exam ultimately as the yardstick by which you determine who gets into the profession or not. Let the bar exam play that role. I'm comfortable with that solution. It's worked in other places, and I don't see why it cannot work here. But I am not going to sit here and say that has to be the only solution. There may be other people with smarter ideas. Let's have multiple solutions on the table, and the GLC must play referee more than just take a position and stick with it and say, this is what we are going to do, and that we're doing it by fiat, and you have to do it or not. I think that way of doing it, that very tyrannical approach is part of what has created this problem. So I think the GLC must step back. That is if we don't dissolve it at all. But I think it must step back, and then weigh all the options, right? Just weigh all the options, get all the stakeholders on board, and then we can make a decision that is in the best interest of the country going forward. Thank you.
Prof, thank you very much. I told you it was going to be controversial, and he revealed that apparently Bentil had told him to say all the bad things. Mr. Bentil, it's your turn now. You reserved you just before the AG for a good reason, because you've been in Parliament fighting this. The law was passed today, by the way.
I know.
Yes.
And
maybe you want to start from there.
I mean, it's sad because you see a lot of politics in that. I can tell you for a fact, if we had 200 parliamentarians in Parliament today, that LI would be shut down. I can tell you for a fact. So there's a lot to say about that. The fact that we can't get even 100 parliamentarians in place for most of the time. That's a problem. And the fact that, you see, in a developing country like this, you must have people who have a certain position about how we should proceed and have the courage of their convictions to even swim against the tide to make it happen. That's how we get development, not just flowing along. So I worry a lot about the quality of people who say, I believe in this, and they tell us off the scene. The majority of our parliamentarians believe in this, but very few had the courage of their convictions. I am told that some had to walk out of Parliament because they didn't want to vote and be seen to be voting against it. So there's a lot to say about that, but it's a battle lost, but we will win this war. There is no way you can leave this thing the way it is, because I know how the AG feels. She's here. Okay, I believe she's progressively minded. She may be constrained and she has to go through a certain process, but I'm speaking for her now. I think she wants a better Ghana. And she's here, so she'll say, if I'm lying, I know. So we all have to work towards this war. We'll win this war. We'll have to change it. My worry is you have 3,000 people sitting back right now. They don't know where they're going. The Supreme Court has made a ruling that affects them, and we are breaking the law on that one. And when this is solved, what do you do with the people in the meantime who are left, without an option? That worries me quite a bit. Then again, there is the option to go back to court, but, well, we'll see what we'll do about that. So, well, there's a lot to say. Let me go on to what I want to share. The law is one of the old professions. Its history is well known. People don't realize this, but in the early days, you become a lawyer through apprenticeship. Your father is a lawyer, your uncle is a lawyer, you hang around him and you become a lawyer. The aunts and that's how you become a lawyer. And very good lawyers were produced that way. Then you had it formalized a bit. Okay, so you go through some amount of education. In the 50s, 60s, maybe 40s, actually way before that. You hear of Mensa Saba and Co. and all those other people. Lawyers who could stand in courts in England and hold their own before English lawyers and before English judges. Hundreds of years ago, we produced them in this country without a law school. But how did you do it? So you have a bit of education, and for those days, most of the people would travel to England and do the apprenticeship, come back as lawyers. Our president's first degree is not in law. So many people could do that, but there was a problem. The problem was that if you couldn't find a way to England or some other place, then you could not really become a lawyer in that sense. Then Kwame Nkrumah said no, for the simple reason that he wanted to expand access to legal education for poor people, for people who could not go to England, for people who could be lawyers, but just for the sake of passage would be denied that. He told Geoffrey Bing and Co., let's set up a law school. Exactly that reason. One, it says for people who could not access legal education going outside, and also to produce enough lawyers to take care of our ordinary folk. That's the stated reason for the law school. So we had that law school. Why it's important is there's a parallel here today. Today you hear the arguments about too many lawyers, and people are saying it's become an elitist profession and they're trying to keep some people out. The law school was formed not to do that. So if there's a sense that it's doing that today, I think there ought to be a certain resistance to that whole idea. All right. So look, you form the law school and you have people who sometimes did not do law. They didn't have a first degree in law. You are right when you say the law school was really not formed for LLBs. Okay? It was formed, and if you read the LI today and the Act 32, you will see that if you did mathematics or you were a doctor, you wanted to do law, that's where you go. They take you through a certain series of, courses, and then you progress. There are lawyers practicing today who didn't have a first degree in law. They went to that law school for 2 years, did an apprenticeship, and they're very good lawyers today. Now, for those who went to law school or have an LLB, here is what the reality is. It's a bifurcated education system. What it means is that it is one system broken in two. The law is not just a qualification, it is also a vocation. Why it's bifurcated is because you can finish LLB and not know how to draft a conveyance. You can finish that and not know how to do a power of attorney. Okay? Now, there is therefore the practical aspects of law, things you need to do. Do a writ. All right? Have this process done. What is this and what is that? How do you go about this and how do you go about that? So you finish the LLB, which is mostly theoretical. And this was supposed to be the place where you go and get the practical learning. That's why it was bifurcated, which is to say, there is no need for another entrance to qualify you to do that. It is a top-up. You do the theory, now you do the practice, and you go and practice. That's what it's meant to be. That's why the entrance examination is not known to this whole system. Okay, so the law school itself was for non-lawyers and or people who did not have an LLB. Now you have a situation where from the 60s when this was conceived, and by the way, the Ghana School of Law is not a creature created by law. It was not. In fact, it's still not. It came about out of exigency. We needed it, we created it. And if you read Act 32 envisages in Section 13 that other educational institutions will be used. It was created for a specific purpose to do some of the things I've spoken about, and the indication in the law, the intentions are stated and written, were that once you get to a certain point, it will not be fit for purpose or adequate for our needs. And therefore, you expand it using other educational institutions. Is written in there. Okay, so you have a situation where from the 60s you have this law school. We trained all of us, 70s, 80s, 90s, and people saw this coming. I read what Max wrote. I've read what Ace has written. Dr. Ayine has written some. All of us have been fighting this battle. If you are, publicly mandate, you get to see. We saw it coming for about maybe 30 years. The leaders there in different discussions, they'll tell you, we saw this coming. But we sat down and did nothing. And that's generally the problem of this country. People are happy to run things when indeed what they need to do is transform them. We did nothing. And there were warnings. People spoke. People argued. When I was in law school, I was having this argument. Okay? People wrote. Our leaders still did nothing. And then we sat down, and young people have to pay this price today. Look, some of them will not find their way after this. There will be collateral damage because of the indolence of some of our leaders. My view is this: if you make a mistake not transforming the system and therefore create this gridlock, which is effectively throwing people away, you should give them the benefit of the doubt. If you made the mistake and did not create the system that we need today, you have a huge system developing or producing LLBs, and you have this constricted bottleneck which can't take them. You should give the young people the benefit of the doubt. People talk about quality. I think HKP has dealt with that. The quality problem is not for the law school to solve, and it's indeed not even their issue. The examination results we got now just takes care of that issue. If the entrance examination was a way to sift out quality and get the best people, you won't get the kind of result you're getting today. And you can't say somebody has gone through 4 years of education and passed properly, and then you use one examination sitting to disqualify them. I am 100% sure that some of the people who did not get admission into law school will ace the bar exam and become very good lawyers. Samson was talking about one of such persons, and we know a number of them. There are people who get A's, straight A's in class. And I remember in my advocacy class, they said the law is theater. Any lawyer knows that. And in certain parts of this country, actually, you don't even need to know law to become famous. You need to just display a lot. All right? That's the extreme end. But what I want to say is that it's not just what you learn in the book that essentially makes you a good lawyer. So the point is, some of the people we are throwing away might actually turn up to become maybe the better lawyers. Here's the conclusion of the matter. The problem we are in today is exactly because our leaders failed to plan. I think the solution should not have been to show where power lay and to say, we want to do this, we can make it happen. But to have given the benefit of the doubt to the young people. Why? Because it's also possible. Law is not more difficult than ACCA. It's not more difficult than CA Ghana. It's not more difficult than CIM. I think nothing stops us, if we want to have all these people registered and find their tuition in the next 2 years. Okay, and let them write the bar examination. Let's give them the benefit of the doubt. If I had time, I'll give you so many more reasons why it must be so. I worry about throwing out over 3,000 people through no fault of theirs. And going forward, I think we must have a certain view of those places where we need to have transformation. Look, this argument is valid for the medical school. This argument is valid for nursing schools. Okay, and for many other places. People are asking, why do we want people to go and become lawyers? No, we just have to start from here.
Bring a perspective to where we are coming from and why we have this on our hands. Again, perhaps I need to state, I do not get the impression, sitting on the General Legal Council, that all this is about showing that you have power and authority. Nowhere, at least for the time I have served on it, did I get the impression that it was intended solely to maintain quality. Neither is it the case that we have enough lawyers, and therefore there must be such an arrangement that will enable us to have a gatekeeping system that will keep as many people out. Reality is that, as my colleagues here have said, we allowed an old system which is no longer workable because of the dynamics that we are faced with now, that we are having to solve the problem this manner. I think that the General Legal Council itself, in seeking to amend the existing law, was at the first time trying to respect what the Supreme Court said in respect of the Professor Esari suit. for some reason, I think the Supreme Court itself realized the difficulty on our hands and actually gave a moratorium. It did not give actual prescription. It said rectify the situation because what you have put in place now cannot stand in the face of the law. I think that is what dictated the steps that the General Legal Counsel is taking now. I'd want to assuage the pent-up feelings of my dear Kofi sitting here. We have to find solutions. It cannot be a war. We don't need to fight battles. We need to speak about these things and find the solutions. The General Legal Counsel, if it were not to make this change, and we said revert to what is the original status quo, what would it be? It would only mean that only law degree holders from the University of Ghana and the KNUST and perhaps any other that the General Legal Counsel is minded to admit would have entrance to the School of Law. For now, it's been trying to admit other students coming from other institutions because we have an accreditation board which is giving accreditation to a number of universities outside of University of Ghana and the UST. So they're operating like two streams without a confluence. That is part of the reason why we are where we are. I have said this, even at my vetting, that it is simply not acceptable that people who otherwise can become lawyers are denied the opportunity because we do not have either the space or faculty or the facilities that can take the numbers that are coming out. I remain by that position. However, we have a situation on hand. If we maintain and we say we are kicking out the amendment, then nobody is a winner, to borrow Ace Nkrumah's expression. Go back and it will even be more limiting in terms of who can enter School of Law. Government's position in this, it was not easy for me to get cabinet to give policy approval for the amendment to be effected and to have it laid in Parliament. Government itself has a problem with what is going on. But perhaps I need to state that we need to separate the two problems we are facing: the processes involved in getting to School of Law and the percentages of failures. I think that coming out, we have somewhat managed to mix up the issues. We need to separate them so that we can begin to look for the solutions. In terms of the processes, government, although is concerned that we must maintain high standards, is nonetheless not happy about the numbers of students who are coming out and are not able to meet their ambitions. So in giving approval, it allowed itself to be persuaded that the alternative of not making this change is not more favorable. And therefore, to legitimatize the arrangements in place in terms of examinations and interviews and the Independent Examination Board, let us do that as a short-term stop-gap. In granting approval, it said the Attorney General must liaise with the General Legal Counsel to promptly come out with a plan towards a long-term solution to the problems that our legal profession training is faced now. That is government position. There have been attempts to come out with quick prescriptions. That also is good. But I do agree that the issue is larger. My friend Inusa Fuzeni here says that it should take just a pen, do this. That clearly is not the most difficult aspect of it. But when we do that, are we able to achieve? For the longest time that I have known it, School of Law has had to draw largely on private part-time faculty. Perhaps you can have Teacher Maxwell here be one of the longest teaching in the School of Law. So should we decide that all the universities that offer law degrees now should immediately, by fiat, be engaged in professional legal training? I don't suppose that we'll get what we want. That is not to say we must not begin to deal with it. And concerning the performance in examinations in the School of Law, the General Legal Council itself had expressed worry about the numbers and had in fact taxed not only the director for the School of Law but also the Independent Examination Board, because the Legal Council and the Board for Legal Education, you don't get to see the scripts. You only deal with index numbers and marks. But you look at the percentages where the line is drawn, and it becomes worrisome. I speak like this because if this kind of system had pertained, perhaps I'd never become a lawyer. Because during my time, I read a combined honors in law and political science. It was only because the late Kwame Afre of blessed memory, when he became director of the School of Law, took a position that the School of Law was autonomous of the University of Ghana. So whether LLB or BA, come over. So when I speak like this because I share the concern of all those who are being denied the opportunity to take up professional courses. Whatever they choose to do with it, it's not. And I do not share in the argument that we have enough lawyers. The comparison with the UK and the US, whereas the UK is trying to limit the numbers, US is trying to encourage people to renew. You cannot do that kind of comparison because US is huge. Their demands may be much more than what might pertain in the UK. They have their different systems, but they're certainly, even for the restrictive system in the UK, they have greater opportunities than we can boast of. We cannot, emphatically, we cannot continue to have a system whereby you have an accreditation board that continues to give accreditation to increasing numbers of universities that are offering law degrees and have a single School of Law, be it with faculties. It is obscene. It is not acceptable that we should have. When I was a student, we had people from our neighboring countries. Our bigger Nigeria, with all its many universities and faculties, came to train here in Ghana. And yet today, we are heading for the Gambia, Botswana, even Nigeria, Rwanda, without showing any disrespect to them. It means that we are doing something very wrong. And government certainly is not happy about it. I have since the decision of Cabinet written to the General Legal Council, conveying the concerns of government and the request to immediately put in place. I see this way forward without intending to give details, that we should look at solution in terms of immediate, medium, and long term. So whatever has happened now can only be the immediate, that it will not last for long, just to contain a situation which otherwise could be worse if we reverted to a strict application of the law as it was. Medium term, I know, by serving on the General Legal Council, that there are proposals for a law village. But a law village, however big, can not be bigger than Ghana, the size of our landmass. That will have limitations as well. I would see that approach as a medium term. The long term, speaking for myself, and I need to emphasize, that is my prescription, that the General Legal Council itself removes itself from direct involvement with professional legal training and becomes a regulatory body. I think I'm barely repeating what I said at my vetting. So, thanks for having faith in me. Kofi, yes. I promise on my honor. I have taken the first step of conveying government position in the matter. I've taken that first step, and I can't promise that we'll continue to find these solutions. Clearly, it would not be a matter for the General Legal Council sitting as a board. And I agree with my brother, the Professor H. I call him H. He tries to hide the Henry, but the name is Henry. I agree that we have a number of stakeholders. It will be helpful, and I believe that will happen, even in trying to pass a law. People start with, let's pass a law. Let's give scholarship for teachers to train. That is starting to pick flowers when there are no fruits. You want to get to the bottom of the principles. That's what I call the diagnosis. And then we can begin to make the prescriptions. I thank you very much.
Thank you very much. Thank you very much. I want to come to the audience now because we invited you here so you can ask questions. Students are here. We've had solutions. The Attorney General has expressed her personal proposal as well. And I don't want us to mistake that. It's not the position of government. That's her personal position on the matter. She's told us what government is doing. But if you look at the bill, the recommendation from the committee that eventually led to the approval, they note that Cabinet has already approved the draft legal profession amendment bill, which was submitted to it by the Attorney General. And also, we are told that the process to introduce reforms, the Cabinet has already approved that bill, and there's another bill, is a draft Ghana School of Law bill that has also come forward, and so there's something happening there. So we've had the proposals. I think from the position that the Attorney General expressed, it agrees, if I'm not mistaken, with the Maxwell's proposal for the Ghana Law to become a Council of Professional Legal Education. Is it the same? Like the Council for Professional Legal Education, so that the